Okay, good afternoon, everybody. I think we now have everyone here. We're going to get started. We'll begin with bill introductions. We have one from Representative Proehl that I know of.
Thank you, Mr. Chairman. I do have one. It's RS 0064, and it's concerning school buses, relating to school bus safety, relating to the illegal passing of school buses. Would you like me to leave this with you?
That would be great. Committee, any questions? Any objection? Seeing none, that will be introduced. Good to see you, sir. Thank you. Anyone on the committee have a bill they'd like to request? Not seeing anybody here joining us today. Okay, we'll move past that. We've got, I think, another week and a half or so, maybe 2 weeks, not quite, for bill introductions. But if you've got them ready, let's get them introduced. If you've got ideas that you intend to have bills drafted on, let me know that as well, because I'm starting to map out what the calendar looks like for the next month and a week, and we don't have a lot of space left, so things are filling up. Committee, we have 2 bill hearings today. I'm going to open the hearing on House Bill 2109 and have Natalie give us an overview.
Thanks, Mr. Chairman. House Bill 2109 would change the requirements for Board of Indigenous Defense Service appointments. Current law provides that each county with a population over 100,000 will have 1 member of the board, and the board will be made up of 5 lawyers and 4 non-lawyers. So this bill amends that statute, which is KSA 224519, to provide that 1 member of the board shall be appointed for each county that has a population over 115,000. And the section is also amended to provide that 6 members shall be lawyers and 3 members shall be non-lawyers. And I can take any questions.
Any questions for Natalie? Representative Carmichael.
Thank you. Ms. Scott, I seem to recall having seen this bill before. Did we have similar legislation perhaps last year, and do you happen to know what its fate was?
Mr. Chairman, you did have a bill similar to this last year. It was House Bill 2449. You guys heard that bill. You passed it out of your committee. It passed on the House floor 99-23. It went to Senate Judiciary. They had a hearing on March 10th, and then it died there.
Thank you for your assistance.
Any other questions? Seeing none, we will move on to proponent testimony. Heather Cessna is here with us today.
Oh, here, does that work this time?
Perfect.
Thank you very much for giving me the time. I'm Heather Cessna. I'm the Executive Director of the State Board of Indigent Defense Services, and I'm here as a proponent for the bill. This is, as Representative Carmichael mentioned during his question, this is something that this committee has already seen and already passed, but because of the shortened session, it just didn't make it out of the Senate last year. We are currently short 1 member of our 9-member board because the governor and the Senate cannot appoint and confirm a new member to our board because of this hink in the statute. And so this was a wording of a correction that would aid us in being able to get that last member appointed while still complying with the new language if the committee sees fit to pass it out. I'm happy to answer any specific questions. Obviously, my written testimony has gone into a little bit more detail.
Good. Any questions, committee? Not seeing any. Thank you.
Thank you.
Is there anyone else here today as a proponent? Anyone here as a neutral conferee? Any opponents? Seeing none of those, I'm going to close the hearing on House Bill 2109. Let's see, now I'll open the hearing on House Bill 2078, and again ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2078 would make some changes to the statutory speedy trial requirement. This bill would have been KSA 223402 to suspend the statutory speedy trial requirement in all criminal cases filed prior to the effective date of this act until May 1st of 2024. And then the bill would also eliminate the speedy trial requirement for all criminal cases filed on or after the effective date of the act. Subsection L provides that the amendments made to this section are procedural in nature and shall be construed and applied retroactively. And if passed, the bill would take effect on publication in the register. And I can take any questions.
Any questions? Representative Carmichael.
Thank you, Mr. Chair. Ms. Scott, could you explain to us what the effect of the definition is, the bill being procedural in nature and having retroactive effect? What does that mean in the context of this bill?
Mr. Chairman, so because this bill purports to suspend the speedy trial deadline for all cases that have already been filed and are currently pending, until that suspension would be until May 1st of 2024. So the retroactivity clause is saying that the suspension that we're doing now, putting in place, suspending that right until May 1st, 2024, will apply to all cases that are currently pending and all cases that have previously been filed.
I've heard somewhere that speedy trial rights are actually vested rights. And I know Mr. Bennett is a bit of an expert on that, but could you explain that concept if you have familiarity with it, because I'm not fully conversant with it?
Well, so the general rule when it comes to criminal changes in criminal statutes are that we can't affect substantive rights retroactively, but we can affect procedural rights retroactively. And so when the legislature intends to attempt to try to apply something retroactively, we insert this language providing that in the legislature's opinion, this provision is procedural in nature and we intend that it be applied retroactively. The court may disagree with you on that and say that it's substantive and not agree to apply it retroactively. But that's how we draft that.
And with the chair's permission, one additional question. In the event the court should find that these are in fact substantive rights, not procedural rights, and that our effort to make this legislation retroactive is ineffective, then does that mean that the people who are sitting in jail beyond the 150-day deadline or 180 days, if they're out on pre-detention release, does that mean their cases are then dismissed because we made a mistake thinking we could change something retroactively that we couldn't?
Mr. Chairman, I would kind of remind the body of the changes that you guys made in House Bill 2016 during the special session. So you did allow the Chief Justice to suspend this statutory speedy trial right. So those cases that were filed after the date of that provision taking effect, it's already been suspended for those cases. But it is possible that if the court decided that this change can't be made retroactively, that some people who are pending trial right now, their cases might not comply with the statutory speedy trial requirement.
Thank you. Perhaps some of our conferees can enlighten us a little more, since this is what they do every day, all day, I think. Thank you very much.
Further questions for Natalie? Not seeing any, we'll begin with our proponents. First up is Mark Bennett.
Representative Patton, by the way, told I can take this off so you can hear me better. So the DA's Association got together on this issue, and so just a quick history, as was alluded to a moment ago by Ms. Scott. We came to the legislature last spring when it became evident that a shutdown was imminent, and what the remedy was that I think it was called House Bill 2016, which was the substitute for Senate Bill 102, was passed, which gave the Supreme Court Chief Justice the power to suspend speedy trial. That power was tied, however, to the emergency declaration from the governor. And so what do we do now since we're coming to the end of that term? I believe March 31st is the, correct me if I'm wrong, but I think it's the date that the emergency powers come to an end. And so what do we do after that? Well, if we had all been back in business by, July 4th or even Labor Day for that matter, it might not have been such a big deal. But we are today, as I stand here, most of the jurisdictions in the state have not had jury trials other than a smattering since March of last year. Johnson County, I know, has been shut down, and I don't believe they begin again until April. So they will have been out. They will not have been trying jury trials for 13 months in the largest by volume in terms of population jurisdiction in the state of Kansas. Sedgwick County, we have been able to sort of limp along since September, trying cases, but I did a quick, before I came up this morning, in January, February, and first 2 weeks of March of 2020, we tried 26 jury trials in Sedgwick County, so in the better part of 10 weeks. Since that time, we've tried 6. So, or 7, I guess last week we tried 1 more. So that just gives you a sense of how things have slowed down. And so what has that done? Well, that has left a backlog. I'll get to that here momentarily, but I want to frame this because we have a couple of 3 options here. One, we could simply leave this issue with the Supreme Court and tie her, as we have, I say her, Chief Justice Luckert, tie her to an emergency act by the governor. My concern with that is there are competing interests. I don't want the speedy trial issue in criminal cases to be tied to the competing interests of whether or not businesses can be opened or should be opened, or whether schools should be allowed or sporting events should be allowed to take place. By co-joining those issues, it has frankly made it far more cumbersome for the criminal justice system. I had to come up this last fall and let everybody know, if this dies or sunsets in October as it was intended to be initially, the criminal justice system was going to be in dire straits. And I know that caused some consternation because those two were linked up. So trying to be very practical here, not ask the legislature to be in this sort of jackpot where they're having to make this devil's choice. That's not a very good option. Option 2 would be just give it to the Supreme Court and let them do it. Don't encumber them with anything, just to the discretion of the Chief Justice. And frankly, I'm okay with that. However, that was, Representative Patton will remember, the first draft that was circulated last March. That was the proposal. Simply let the Chief Justice have this discretion. But there were concerns about that. And so my thought was, I'm not here to argue that point, but why go back to the well on something that's already been considered and rejected? So that didn't strike me as a viable option. It's not one I'm opposed to, but I need to get something passed. And so I'm not going to offer something that I don't think has support. Option 3 would be don't ask for so much time, not 3 years. Let's go back to maybe 1 year or 2 years. The concern there is if we had been back to something close to normal in terms of ability to try cases by now, then maybe 1 year or 2 years would be sufficient. The question I pose, and it's not meant to be, it's somewhat rhetorical because no one really knows the answer, but does anyone really think that we're going to have enough of the shot out, the vaccine for everybody, that we can be truly bringing in people for, this isn't just a matter of lawyers and judges. This is jurors. We need jurors to come through the courthouse doors of all 105 counties in the state. When do we think we're truly going to be able to say, okay, it is okay to come in and sit shoulder to shoulder in a gallery as you're picked for jury selection for the first day or two, and then sit shoulder to shoulder in a jury box, and then go back into jury deliberations? If we really thought that could happen by April or May or sometime this summer, that'd be one thing. That would affect the calculus, to be sure. But when we know, I think most of us understand, it's going to be a while. The article that was, I think, in the KC Star, and I know it was in the Eagle last week, was Kansas has received 1% of the vaccine thus far. It's been a slow rollout. And so I don't want to be back here in 1 year going, okay, we've been given 1 year, but we've just started doing jury trials en masse again in September, October, maybe August, hopefully. That will not be, 3 or 4 or 5 months before we're back in front of this legislative session in the 2022 session. Just isn't going to be much time. So that's where we thought, realistically, this next year is going to be battling to get back to normal. And then about a 2-year window to try to work this backlog down. I will say, I understand there's a, maybe there's some folks who think 3 years is too long. My only response to that is, frankly, I'm here with my hat in my hands. I'm not in a position to negotiate. I have to have something like this. If it dies in March, hundreds, maybe thousands of cases there's no way we can try them all. I need, just in Sedgwick County, just for my off-grid offenses, I need 5,300 some odd jurors just to try the off-grid offenses in my jurisdiction. There's 1,400 people in my jail right now. Unless anyone think, well, quit sending all the misdemeanor marijuana people in there and you wouldn't have so many. Not a single person is in Sedgwick County Jail for misdemeanor marijuana. I think I have 29 people out of the 1,400 who are in on felony possession level of drugs. Everything else, we had 59 murders last year. We set an all-time high. 150 some odd shootings as of October of last year. I didn't get a chance to count the last 2 months. We have serious cases we have to attend to, and I don't want to be in a situation where I have to choose which murder case gets prosecuted and which ones get dismissed. So if that sounds hyperbolic, I wish it wasn't. I'm not one to come up here and the sky is falling, but these are the numbers we're dealing with. So I asked for some of the major jurisdictions and the bigger ones to respond. I haven't heard from everybody, but just to give you a quick sense of this, so it's not just a Sedgwick County problem. Barton County, 40, and these are just pending jury trials right now, folks who are past arraignment. 40 in Barton County, 86 in Butler County, 12 in Dickinson, somewhere between 150 and 170 of the 517 pending cases are in Douglas County, 35 in Finney, 35 in Franklin, Johnson County 400 to 500 in jury trial settings. I've got 468 set for jury trial right now, and I've got another 380 who are post-prelim. They've had a prelim, they're just waiting on their arraignment. So truly closer to 800 cases are ready to be tried. Not all on the same level. 138 are off-grid, 211 are top 3 levels. But that gives you a sense. Shawnee County, 647, that gives you a sense of the volume we're dealing with here. So what to do about it? We cannot bring jurors in and expect them to show up unless we can assure them there's some degree of safety. We need witnesses to be here. We can't, once the jury's impaneled, if witnesses don't show up because they're suddenly under quarantine, jeopardy's attached. We've got issues there. So it's a very difficult task to attend to. The thing I'd underscore is this: nothing we do changes constitutional speedy trial. You couldn't do something about that if you wanted to, and I wouldn't ask. This is simply a statutory provision. This state years ago made a determination that they wanted to add a statutory speedy trial provision to ensure that on top of the constitutional protections, there was a statute that at least underscored the need for cases to be processed in a timely manner. The final thing I'll say is just double checking. Yeah, the final thing I want to say was there's also an additional request in here, and that is that this body consider whether or not a speedy trial is a statutory speedy trial, frankly, is something that's even needed in Kansas. I'm not going to spend a lot of time on this because, frankly, I think it's something you shouldn't consider. There's a strong argument against it. But frankly, at this point, my main ask here is the stay. We need time to catch up to the cases that we've not been allowed to process through. But on the subject of the repeal, here's how this works. I show up to a preliminary hearing. The preliminary hearing is held. The judge typically goes immediately to what's called an arraignment. How do you plead? I enter a plea of not guilty, demand a jury trial. Thank you very much. I will set your jury trial on, and then the question arises, when? Most of the judges, if they have a vertical situation where it's assigned to a specific judge, and that's, I think, across the state now, that's how everybody's doing it, the judge will look and say, my first available date is, and it might be 140 days out, 120 days out. All of that time is counted against the state. And so if we show up on that first jury trial setting, I have not asked for a single continuance as a prosecutor, and I have a cop who's been deployed, or somebody who's sick, or we just can't find a witness, I now have 10 days or 20 days or whatever it is left until that 150-day mark to try to ask the judge, can you squeeze me back into your calendar? Meanwhile, other cases have been set and set and set. And we could lose cases, not because, and by the way, the defendant can take as many continuances as he or she is allowed to take, and we could still lose on the statutory speedy trial. So the question is this really a statute that protects people's right to a speedy trial, or is this simply a matter of math? And the case out of Douglas County last year is a good example. A homicide case was dismissed. And by the way, when we talk dismissal here on a speedy trial violation, that means dismissal with prejudice. No do-overs. Don't let's make you start at the back line and start again. It's done. Not because if they'd have started on Monday, his due process rights were protected, but by starting on Thursday, 3 days late, dismissal with prejudice because somebody miscalculated who it applied to. So that being said, if that is offensive to the body here and others, I get it. There's a time and a place for that conversation, and I wanted to at least get that in front of everybody. But at the end of the day, we can agree to disagree on that, and that may or may not carry the day. The stay, the ability to say speedy trial must be suspended for a period of time, I just don't know how else to put it. It's non-negotiable. We have to have something, otherwise we are going to be in really dire straits. So again, the options available to you all are as set forth in the statute. Give us 3 years. If that is if that's a bridge too far, then at the very least make it 2, and I would ask that it be May of the second year, so I have time to get back in front of you on that second year and tell you where we are. 3 years, I'm more comfortable with. And then the other option is to simply give it back to the Supreme Court. But again, there's putting cards on the table here. There's no subterfuge, no dancing around this. I want to do the least politically charged thing because I need to get this bill passed. So there's much more, obviously 3 pages of written testimony, sets forth the position of the DA's Association, but I wanted to at least put this in a little more real terms for you, what we're up against. So I will certainly stand for questions from anybody who might have any.
Very good. First up is Representative Samsel.
Thank you, Mr. Chairman. Can you hear me okay?
Yes.
Excellent. I apologize if there's background noise. We don't have coffee shops here in Overbrook, Kansas, so this is from a bar of all things, a place that had Wi-Fi. But I was hoping I could start with the reviser very briefly, the good reviser, if she could help us, at least help me understand, and maybe for the non-lawyers in the room. I understand that this does not impact the constitutional protections for a right to a speedy trial, but I don't do a whole lot of criminal law. And when I look at the bill brief, I don't know what that constitutional protection is. Can she help me understand a little bit of the overlap between, yes, we may be altering statutory rights, but what fundamental Kansas constitutional right is still there?
Mr. Chairman, I can attempt to answer that, and I'm sure that Mark can elaborate on that as well. The statutory speedy trial right that you see here, it's very definite. It's 150 days, 180 days. The constitutional right, like a lot of constitutional rights, it's not quite that definite. It's more like a test. And so it's going to be not as specific as the statutory right is, but like Mark alluded to, we're not making changes to that. We can't make changes to that here in this bill. So this would just be getting rid of the statutory provisions.
Could I add to that? Oh, you're muted, Mr. Representative Sampson.
Hey, Mark, would you unmute yourself? I muted yourself because there were people, partying in the background.
I'm very sorry about that, Mr. Chairman. It's the only spot I could find with Wi-Fi. Yes, I'll be quiet so he can respond as well.
Yeah, so I'll just add, there's no determinant, there's no 90 days, 150 days, what the case law says, and I put some of it in the written testimony. Basically, it says there becomes a point at which speedy trial being extended out from the point of usually from of either arraignment or from the charging document being filed until somewhere around a year. Most of the case law recognizes that you get past much past a year, you're probably talking about something called, that's referred to as presumptive prejudice, at which point that triggers the analysis under the Barker versus Wingo decision, which is a 1972 case. And then they start looking at weighing different factors. There's 4 of them. I set them out here in the written testimony. And that's still, frankly, the elephant in the room here. We're going to see how does the Supreme Court of the United States assess what speedy trial means during a pandemic. I mean, they have the option of saying a year is too long. It doesn't matter what was going on. They have an option of saying, what was anybody supposed to do? That's one thing I'd point out is we are not unique in Sedgwick County or in Kansas for that matter. Every state in the union is dealing with this right now. So.
Thank you. Mr. Chairman, my last question, if I may, is address proponents as well as the opponents, but I read from the Kansas Association of Criminal Defense Lawyers testimony, and it's, quote, "We absolutely oppose the elimination of our statutory speedy trial provision, and we oppose the proposed suspension of statutory speedy trial in its current form," end quote. And as I read the testimony there, very heartfelt, but it also seems to focus on statutory rather than anything constitutional. So I think that's important. But I would like to hear from the proponents just speak as to a practical matter. Just because we get rid of these statutory, stricter, more detailed guidelines, I suspect the practical realities, but tell me if I'm wrong, and certainly the opponents may. But we are still going to pursue these things with all speed possible. I assume it doesn't do anybody any good to not go through these things in a speedy fashion, if you will. That would be my last question, Mr. Chairman. Thank you.
From the proponent's point of view, we have zero interest in delaying these any further, frankly. Part of the difficulty right now is the caseloads. I've got attorneys with 60, 70, 100, 120 cases. I'm personally I've got 10 homicides that I'm prosecuting, 5 of which are capital murders. I took one more yesterday. I guess I pled one last week, so now I've got 11 homicides that I'm handling myself. The idea that I want to stretch this out and delay this because I'm going to gain something from it is ridiculous. The cases never get any better the longer they drag out. Witnesses are gone. I've got a case right now, a homicide case, where some of my witnesses have died. It's taken so long to get it through the system. So, the notion that we're going to delay things, number one, we have zero interest in that. Number two, judges wouldn't let us. They've got to move their dockets as well, and they're going to set things and expect us to show up and be ready to try it. And if we're not, my expectation is they'll dismiss our case. So, no, this is not a matter of, what this is a matter of is simply looking at this deluge of cases and saying, can I get these tried in the minute this goes away, this emergency order goes away, can I get all of these cases tried in 150 days? And in Sedgwick County, what that means to me is I need 5,000 jurors just to handle my off-grids in 150 days from March. I mean, it's not going to happen. And anyone who thinks it can or that I'm, that have some ulterior motive, I'd like to hear your explanation of that.
Representative Carmichael.
Thank you, Mr. Chairman. Mr. Bennett, I do appreciate the predicament, and it's not just that you are in, it's a predicament that all of us are in, whether we're citizens or lawyers or legislators, because it's important that we have a system of criminal justice, and it relies upon people going to trial sooner or later if they don't plead. So I want to work with you on this. The 3-year extension that you propose here would, I believe, be on top of already what amounts to almost a 1-year extension. Am I calculating the numbers correctly?
You will, but excuse me, you will by the time the current suspension dies. I think March is, again, I think it's 31st, so that would be, what, 1 year and 2 weeks.
But there, you should understand there is some hope for our legislature that perhaps we'll be extending that beyond that, but I understand you can't depend on us to do an additional extension. But I guess my point is, at least theoretically and as a practical matter, if we pass this, at least under our speedy trial statute, we can have people waiting 4 years in the county jail for their trial. Is that correct?
It could happen, yes. The bottom line is I'm trusting that judges are going to look at the cases and see which one's been in there the longest, and they're going to make an assessment over which ones are the first up. I mean, the judges set their calendars and they'll decide which cases go first. There's an additional quandary in all of this, which is a little counterintuitive, but the existing constitutional speedy trial case law seems to indicate that the more complicated the case, The more difficult the case, the more leeway they'll give for constitutional speedy trial assessment, less so for the less serious cases. So we may be in this quandary as the judges are trying to set their calendars as looking at something that is a fairly simple case. A guy walks in a liquor store and does a robbery. One witness, surveillance tape, okay, how complicated can it be? Judges may end up putting some of those cases up front earlier, but to answer your question, could somebody? Yeah, somebody could. But again, remember, the DAs aren't going to just sit here and go, I'm going to decide who gets to go first. Judges set their calendars. What I'm saying is, if I am given an arbitrary number of 150 days, I can tell you that is not going to work.
Well, Mr. Bennett, I'm relatively certain that we're going to give you more than 150 days. The question is, do we give you 3 years, or do we give you 2 years and a few more months as is your fallback position, so that we can monitor this situation and see how soon we can start to reduce the backlog, because none of us know, and how quickly we can reduce the backlog once we're back, as former President Trump says, the virus miraculously just goes away one day. So for the time being, can you get by with a 24-month, if you will, extension and run it to the end of the legislative session? Certainly with the understanding that we'll be open for business here, and you can make a good case 2 years from now that you need an additional year, or maybe an additional 2 years, that you'll come back and see us. Would that present a major problem for you at this point in time to scale it back a little bit, particularly when we don't know what the United States Supreme Court or even the Kansas Supreme Court is going to do about constitutional speedy trial in the context of a pandemic when courts are closed?
Yeah, I mean, I was trying to think the other day, I bet I've done this, testified before one body or another 70 or 100 times over the last 20 years. So I certainly understand how the sausage is made, and if that's what the legislature is willing to give us and go to 2 years until May of 2 years from now, okay, yeah, I'm not going to complain. I asked for 3 because I have more, I'm more confident that we can get through it in that period of time. If the first lobby was 1 year, I don't know why. I mean, we're not going to get through in 1 year. That's just.
Yeah, and I don't propose that either. I agree with you. We're not going to get it done in a year.
But if 1 or 2 years rather is what everybody can agree to, I'll take it. I may see you here in 2 years. I hope not. But yeah, I'm not going to complain as long as we divest it from the political. So we're not arguing about emergency orders and the governor and whether he or she should do what they are doing and businesses and all that other stuff. But keep this at least confined to the assessment of speedy trial. And if we can do that and get 2 years, yeah, I accept. I get it. I mean, my ask is 3, but if 2.5 will do it, I'll accept.
Now, I will also grant you, Mr. District Attorney, that you're up here way too much. You're a man with multiple major cases to try, one of the largest law firms in the state to run, and I'm sorry that you have to spend so much time up here convincing us. And in some ways, I want to take that into account too. But let's turn now to the proposal that we eliminate statutory speedy trial rights in Kansas. Barker versus Wingo is one of those cases that I think you and I actually learned in law school together that's still probably the controlling law. But as I understand it, the courts look at a number of factors to try to determine whether or not a criminal defendant has been denied a speedy trial. Is that generally correct?
4 specifically, yes, sir.
Okay. And that's what I was just getting ready to say. Would you mind helping me? Because that class from Paul Wilson was 40 years ago, and I've forgotten what the factors are. Do you have them handy?
Sure. So for everyone else, page 2 of my written testimony, top of the page. Again, the sort of threshold question is, have we reached the point at which we're presumptively prejudicial in the first place? And if so,
presumptively is generally at about 1 year, isn't it?
Give or take. I mean,
Okay.
If there are cases that are less and cases that are considerably more, but I think that's a fair line in the sand. But then you, as you said, you get to the four factors: the length of the delay, the reason for the delay, the defendant's assertion of his or her right to a speedy trial, and then four, the prejudice to the defendant. And that's typically, number four is going to be, did witnesses die? Did evidence decay? Did something substantive, tangible affect his or her right?
The argument, of course, being here that there's plenty of good reason with the courthouse closed to delay constitutional speedy trial, being the converse of that. But I guess my point is that statutory speedy trial laws draw a bright line typically that you have X number of days after a particular date or event within which to get the case tried, whereas constitutional speedy trial, unfortunately, is something that's oftentimes decided by judges in retrospect. In other words, after the deadline is run, they say, aha, the reasons weren't good enough or the prejudice was too great and the case is dismissed. Whereas statutory speedy trial gives us a bright line date by which we have to get a case tried. Is that generally correct?
Yeah, I mean, it is. I have seen speedy trial, constitutional speedy trial claims raised pre-trial, and a trial court judge is in a position to do the same analysis that an appellate court would do. So yes, that is it's not always in retrospect, but typically, let's put it this way, the case law is always in retrospect. Some appellate court is going to decide whether or not the trial court made the right decision. So ultimately, it's always an appellate court that makes that call, yes.
So long as we set our speedy trial deadlines within the constitutional speedy trial requirements, so long as we set our statutory deadlines within that, even though that may be a somewhat varying target, we really lay out a statutory tripwire that we all know where the deadline is. And hopefully that deadline is set before a court would ever have to look in retrospect and say that you've violated the constitutional right either under the Kansas Bill of Rights or under the United States Constitution. Generally true?
Yeah, I mean, there's going to be a bright line. The only question is, to whom delays attributed? Did the defendant ask for it? Did the state ask for it? Was it the court's inability to be present? Those sorts of things.
But of course, even in the constitutional context, the defendant's demand or request for speedy trial is also taken into account. So I think as a general concept, delays chargeable to the defendant usually aren't counted against the state, certainly not in statutory speedy trial, but it's also a factor in constitutional speedy trial, isn't it?
It is. The concern with statutory, though, is we can be boxed into a corner where he's asked for continuances until, a date certain, and now we're down to 10 or 12 or 30 days. But yes.
So another alternative, and I'm pretty well done with this, but a different alternative would be, rather than revoking the right to speedy trial in Kansas, and we're not talking so much about the pandemic created problems here, but we're talking about going forward, presumably after this is all over.
Yes.
We could give you more time. We could maybe, instead of 150 and 180 days, run that thing out to 300 and 365 days, and that would give you a better opportunity to deal with the missing or unavailable witness and take whatever steps you need to take to preserve or present that testimony. Would that be an alternative in between just completely eliminating statutory speedy trial in Kansas?
Yeah, there are, I mean, if you want to really take up the issue of repeal and whether or not we want to do it, obviously the membership asked that we forward this piece of legislation. However, if we're going to get into the sort of the back and forth on another way, yes, extending speedy trial for a longer period of time would be option one. Another option that some states have is change the remedy. The remedy in Kansas, if speedy trial, if you get past 150 days, it's dismissal with prejudice. So a colleague in Wisconsin told us that the remedy up there is release on bail. Let the person out. I mean, if the whole point is that they shouldn't be sitting in custody awaiting their day, instead of dismissal, then give them a lower bond, or just give them no bond, or just bond them out OR. Another option would be to say, count against me any delay that I am responsible for. So in that example I gave earlier, we go to the judge says, okay, first jury trial setting is 120 days out. So that first 120 days is counted against the state. I had nothing to do with that. I don't have control over the court's docket. But if I get up there and say, you know, I haven't gotten it together, I'm not ready, I need 90 more days, okay, count those against me. But if my ability to get back into the court schedule, I mean, I'm booked out for 6 more months, that's a court schedule, but attribute anything that is my responsibility to me. That's another option. I guess my point is there's lots of ways we could slice this to keep speedy trial, but make it less draconian, frankly, in its remedy for a violation.
Well, Mr. Bennett, you and I found a lot of common ground just sitting here. And I also want to confess to you that you started to explain some of these concepts to me at about 5 o'clock a week ago Friday. And I cut you off because I pulled up at the liquor store and I had different priorities than you at that moment. But I always appreciate your advice and your cooperation and help. And thank you for taking the time to be here. Thank you, Mr. Chair.
Yes, sir.
Representative Hoheisel.
Thank you, Mr. Chair. And thank you, Mark, for being here today. A couple quick questions. You know how many states currently have a statute of limitations actually in statute?
I spent some time looking for that, trying to just see where we land, and the best I could come up with was something I included here. It's called a Cjs Subsection 820, and all it says is that a number of states have enacted statutes, and then they kind of go through some of those states. But if I added them up, there were only 14 or 15, and I can't believe it's that low. It's got to be more than that, but I can say with some level of assurance that not every state does. I do know that not every state's remedy, meaning, okay, if you violate it, what do you do? Not all states have the same remedy we do, which is dismissal with prejudice. Some, they have different, okay, if this, then that. So that's the best way I know to answer that question.
Okay. And do you know how, I guess, those states I mean, I assume they're facing the same backlog we are here in Kansas. Do you know how any of those states are currently dealing with this? Are they asking their state legislators for?
Yeah, they'll, as I understand it, states that have a statutory speedy trial have had to either pass a statute that did what Kansas did, allows their respective Supreme Courts to suspend, or there are states where I believe that's in the inherent power of the court to simply do that without legislative action. They didn't need a law to do that. The Supreme Court just controls that. But yes, some affirmative action has had to been taken. Otherwise, you'll have somebody who's violated statutory speedy trial in that state.
And last question, Mr. Chairman, if I may. In your time as a Citrus County DA, how many cases have we, I guess I should say, lost due to the speedy trial provisions?
I've worked there since 97, so 23, 24 years now. I remember one. And it was a case where it came down to whom was a continuance grant attributed. And there was a big conflab over whether the state had asked for it, the defense had asked for it. It was something done at a sidebar. State versus Gore is the name of the case. Now, there may have been another one that slipped my mind, but in all the years I've worked there, I can think of us losing one case on speedy trial. So my point, that's a good point. I don't know if you meant to throw me a soft one here, but I'll hit it. That is, if it wasn't for a pandemic, I wouldn't have wasted my time driving up here today. I wouldn't have asked for this. We have never had trouble meeting our statutory speedy trial obligations. The question is, what do we do in this wholly unique time? And while we're talking about it, it does beg the question, in light of the Queen case from Douglas County, is this really the way we want to proceed on a statutory speedy trial? Do we really need one? And if so, then maybe we have the conversation that Representative Carmichael discussed a moment ago. Let's get down to a little bit of haggling back and forth and make this something that everyone can actually live with, that fits the rights we're actually trying to protect.
Thank you, sir. Thank you, Mr. Chairman.
Representative Wheeler.
Thank you, Mr. Chair. Thank you, Mark, for being here.
John?
It sounds to me like you're here out of desperation.
Trying to avoid desperation, but I'll accept that.
Well, I'm sitting in a chair where I don't avoid it. And I understand why you're here, that you are limited to hopefully getting this body to extend the statutory right of speedy trial, but looming behind you is the constitutional right of speedy trial.
Absolutely.
And that's not defined, nor, to my knowledge, since I don't have Westlaw or anything anymore, I'm just a poor retired lawyer. the ones that have ruled constitutionally don't grant that much time from what I've seen.
Yeah, I mean, like I said, I was trying to find like even a median, what I could give you sort of an average or something. I found cases that were 300 days, a 19-month case. There were cases that are death penalty cases that are 3 and 4 and 5 years that it's okay. So it's difficult.
70 days.
Yeah, yeah,
I mean, they're all over the chart,
sir,
and you have no way to know.
correct.
Now, it does seem to see that blanket orders of extension seem to be somewhat in disfavor without evaluating individual cases. I'd like for you to respond on that because I may or may not be correct.
In return, I want to clarify. So when I'm a judge and I say I'm going to just simply move 50 or 100 cases en masse, or are you talking about legislative actions?
No, I'm talking continuing cases like retroactively en masse and prospectively en masse without evaluating individual cases and the facts involved. In other words, this guy's old and may die.
Sure.
The primary witnesses in this case are old and may die. I mean, I'm just.
No, sure, I have a better feel, I think, for your question now. So the first thing I'd say is, just to set this up, you've got the question that I believe Mr. Representative Carmichael asked Natalie early on, which is about this notion of vested rights. So the first question is, can you even do this legally? And because a preliminary hearing, or rather a speedy trial, is a statutory animal, at least in terms of the statute, you don't purport to change anything constitutionally. If it's a right that's been vested by the person, I've been charged, this vests with me, I think it's a right that you give you, it's a right you can suspend. So in terms of that, the legislature could do this en masse. Then drilling down, I'm a judge, and I just stand up and say, I'm going to terminate, or I'm going to continue every case in my jurisdiction for X number of days without doing any sort of specific articulation. I think that would be problematic. I agree with that.
Are you able to do that in your jurisdiction with all of the cases that you have? Is that even possible on the docket of the court?
Now, we have 10 separate criminal jury trial judges. Each one calls his or her docket. Each one, when it comes to a jury trial continuance, is going to bring the defendant in, or under the current circumstances, have them appear by Zoom or in person. They can do it either way. And once jury trials are set again, do you need a continuance? Are you ready to go? And continuances will be granted on a case-by-case basis. They have to be. I mean, it has to be that, as you say, as you're alluding to, a case-by-case analysis.
But they are going to be continued.
Can't try every case the first week out. I mean, and one of the consideration here, and it may seem disingenuous for me to even suggest this, so I'll stick to my side of the room. But there's only so many cases a prosecutor can try in 1 year. There's only so many cases the defense attorney can try. And I would like to think we're all capable of everything. There's a reason I have five capital murder cases. It's because I'm still the only person in the office who's been around long enough to have tried capital murder cases in my office. Not every public defender is going to handle murder cases. Not every public defender is going to handle child sex cases. They require a high degree of skill. So if I'm one of those lawyers and I've got 40 of those, how many cases do we really expect somebody to try in the course of a year? In my first year in Sedgwick County, I tried 22 jury trials, felonies. I was in a jury trial every other week, and that was a breakneck pace. I was a much younger person then. I didn't have kids. But to suggest that I could, but I spent 1 year, I tried 2 capital murders, another murder. I was in court, I believe, 24 weeks of the 52. And let me tell you, it about killed me. And to suggest that we can just say, it's time to step up and everybody get back in the swing of things, it's asking a lot of judges, of jurors, and of those defense attorneys and prosecutors.
And you're preaching to the choir.
I understand.
But I am concerned, along with you, I mean, you're looking for the extension of the statutory right of speedy trial. And I recognize that is a reviser's rule that if you're going to go retroactive, you've got to call it procedural. I have difficulty calling a Sixth Amendment constitutional right to speedy trial procedural as opposed to substantive. But it's all you can do. All you can do. I'm wondering, is there anything that is available to you that you can do to show good faith? Because we're looking at a federal court down the road. There's no question about it, and we know how they're ruling.
So all I can do is every day show that we're working. So for instance, in Sedgwick County, since September, we have had jury trials. Since November 30th of this past year, so today's the 26th of January, we're talking about 60-ish days since that day. In the last 60 days, we have removed 120 cases, felonies, from the jury trial docket by mechanism of some kind of a plea negotiation. We are working, we are moving, and all we can do is each day show that, so that when some court goes, what did you do for those 13 months? Just sit around. We can show the number of cases that were resolved.
Maybe out of your, may I, Mr. Chair, you're the major jurisdiction in the state of Kansas, but we have much smaller counties, and some of them are actually having trials. Very low COVID rates, but this would apply to them as well, would it not?
Would, and again, I think they've got the same motivation though, and that is to get people in and done as quickly as they can, because the cases don't stop. I'm glad you mentioned the smaller jurisdictions for just a moment. If you'll indulge me, I want to make sure that voice is heard as well. In some of the smaller jurisdictions, they have what we used to call and still appropriately refer to as circuit judges, a district court judge who will go through different counties within a district. That judge may only be available for 1 day a week. And every fourth week, they'll try a jury trial in your jurisdiction. So it's not as if you have the option of trying one case a week, even if you're in Smith County. I know from talking to the Smith County attorney, for instance, they're already setting jury trials out in 2022 because they don't have a judge that's going to be here other than that. And so different realities than what I'm dealing with. I got judges. I got 10 judges. I just got too many people. They don't have too many people, but they have one judge. So different issues, but the same reality faced.
Appreciate what you're doing, Mark. I truly wish we had had a court reporter in here to take your testimony, to show good faith.
I would have made it part of the record.
Thank you, Mark.
I think we're all on YouTube. It doesn't go away anymore, so it's out there somewhere. Any other questions for Mark? And if there's anyone online that has a question, try to get Representative Ralph's attention, because I'm like my middle school daughter who failed to charge my computer today, and it just went to sleep. So I'm going to try to look way up, but Brad Ralph's going to help me. So if there are no more questions, Mark, thanks for driving up today.
Thank you. Appreciate your time, folks. Thank you.
Next, we have Brandon Jones, who's walking up here hoping that Mark got the brunt of our questions.
Going behind him was intentional, I can assure you. Good afternoon, Chairman Patton and members of the House Judiciary Committee. Thank you for allowing me to address this important issue. My name is Brandon Jones. I am the Franklin County Attorney, and I'm also the current president of the Kansas County and District Attorney Association. If it were non-COVID times, we could fill this room with the prosecutors from the state on this issue. In my 21 years, this is the most pressing issue that I've ever testified on, and the biggest issue we've faced. In Franklin County, we right now have 35 jury trials backed up. That pales in comparison to the numbers Mark told you. But while Mark, he hit on the small counties at the end, but the reason I'm here is to talk to you on behalf of the entire state and the smaller counties. We only have one judge, unlike Mark, who has 10. We have one judge who's assigned to hear our criminal cases. Mark, I think, has 30 plus attorneys in his office. I have 4. So a lot smaller number, but it's the same problem. Our judge just talked about yesterday that when the things let loose, we're going to be trying a jury trial a week. And with only 4 attorneys in my office and 1 judge, that's going to be tough. The other problem is, I think we need to confront, is we only have 25,000 people in Franklin County. And that's actually a fairly big county once you get past the big ones. The other counties I used to represent had 17,000, 8,000. You can only go to those jurors so many times before you're going to start getting pushback from the community of not wanting to be called into jury service nonstop. So the problem is real. And the question is, what do we do to fix it? As Mark already talked about, we're asking for the 3-year extension. I understand that Representative Carmichael and others might think that's too long. And like Mark, we're hat in hand. We'll take what you can give us. I think that 1 year would definitely be just us being back here a year from now doing the same thing. Yesterday, I did a whole docket in front of my district court judge, and we had several of the cases that we'd set over from November and October and continued them to late January, hoping we'd be able to start setting jury trials. We can't. Our plan has not been approved by the Supreme Court yet. We don't have the resources to put up the plexiglass, and we don't have the space to do this. So yesterday, all of my cases that were people requesting jury trials got set out till April the 19th. That's the next time we're going to try to take it up again and see if at that point we're getting anywhere close to where we can actually start setting jury trials a couple months out. So the reality is I think we're still months away from even being able to start setting the jury trials. Then we've got to start trying them all. And like Mark said, it's just absolutely impossible to get them all tried in the 150, 180 days. So that's why we're here asking for an extension. And like Mark said, while we're here, a lot of prosecutors in the state are like, why can't we just get rid of statutory speedy trial? We don't need it. There's constitutional speedy trial. And I'm not going to fight. It's not the hill we're here to die on. If you want to take that up, like Representative Carmichael, the different changes we can do to that, there's some good reasons for it. And Mark pointed it out. It's common in the small jurisdictions too. We have one judge. He not only does a criminal docket, he also does a domestic docket, so divorces. A lot of them will do civil as well. So it's very common that a jury trial, when they request it, it can't be set out till 120, 130 days down the line. And that's fine. We can get ready and we'll be ready to go on that. But what happens on that date when the jury trial comes and it's a January and we get a 12-inch snowstorm and the courts get shut down? Again, it's absolutely no fault of the state, but that case is going to get continued, and there's no way it gets reset on the court's docket within that 10 or 20 days left in speedy trial. Is it fair to the victims that a murderer gets to walk because we had a snowstorm and a court's crowded calendar that's no fault of the state? I think the answer is obviously no. So I think there are better solutions, such as, again, if you want to keep statutory speedy trial, let's let them out of jail if they're in custody, or let's look at all other alternatives. But that can be a discussion for now. If we're going to tackle this, why not tackle it all? Or we're certainly willing to say, let's not even mess with that. Just help us out with an extension. But basically, Mark also talked about the one thing I was going to say is the Smith County attorney, he brought her up at the end, kind of stole my thunder here, but that doesn't have near as many jury trials set, but she's only got a judge in her county a couple days a month. And she's sharing that judge with 6 other counties. So it's unique at all levels. It affects us all the same, whether it's Mark with his 150 people and 59 homicides. We luckily didn't have any homicides in Franklin County last year. But unfortunately, we had plenty of people who molested children who are in jail waiting for trials. We have plenty of people who are dealing large amounts of methamphetamine who are in jail. And we're doing the best we can. And as far as I heard, to answer a question about good faith, the sheriff, the chief of police, and I sat down in March and again in May and went through our jail rosters. We let out as many people as we could. We tried to release anyone who was nonviolent, anyone who we thought that it would not be a public safety concern. We've tried to let them out. We've tried to get people out and preserve defendants' rights. But you can't just let a child molester go, that a person we believe to be a child molester, if we feel the public safety is in jeopardy. And despite all that, and another thing as far as the good faith, to answer your question, we're bringing in at the end of next month a criminal mediator. It's something new in the criminal justice system, but Johnson County started using it. We're actually bringing in a retired judge that the district is paying a lot of money, and we're putting 5 to 6 cases on one Friday in front of him that are cases that are set for jury trial to try to mediate them and see if we can get resolutions. In my office, I've tried to be, I want to say soft on crime. That's never a good thing to get on the record here, but we have tried our best to be reasonable, overly reasonable, in resolving cases and getting cases moved. But you can't plea out a murder down to jaywalking or something like that and do our jobs as public servants to keep the community safe and make sure the victims get justice. So for all of those reasons, we feel that this is an absolute must, that we come to you asking for this. And we feel that constitutional speedy trial is still there to protect the defendant's rights. And with that, I don't want to take up too much of your time because I know Mark went into this in great detail. I'm ready to stand for questions.
Very good. First one up from the Overbrook Tavern, Representative Ralph. Oh, not Ralph, sorry. Ralph who texted me. Representative Samsel.
Thank you, Mr. Chairman. I don't know how you knew the vice chairman was back behind the bar, but I'll leave that one for now. We'll let him explain that. I want to thank Mr. Jones for being here. I've had the privilege of working with him in Franklin County, Anderson County. He's one of the best in the state, if not the best. I appreciate him taking his time. On a personal note, very quick out of everybody's respect of everybody's time here, but what they're doing in Franklin County, working with our sheriff, there was a woman walking miles back and forth to get to work. Our sheriff's department and working with Mr. Jones' group, I'm going to brag about them because they went out of their way to donate money and get this lady a car to get from point A to point B. I do want to make sure I don't really have any interest in getting into the larger debate. I apologize if I sparked that. The constitutional stuff, whether we get into eliminating it on a permanent basis or not, I don't think anybody's here asking for that. So hopefully in the weeds, we can find a solution. The one very narrow question that I would like to ask for Mr. Jones it's again, back to the Kansas Association of Criminal Defense Lawyers testimony. And they say we absolutely oppose the elimination of our statutory speedy trial provision. In light of our very good conversation, I get what that means more now. And frankly, I think that's reasonable. That's a debate probably for a different day. The question I have here, though, is then she says, we oppose the proposed suspension of statutory speedy trial in its current form. So I'm hopefully in the weeds on the current form. That's something we can all agree on. And my very narrow question for Mr. Jones is, I suspect we have very good attorneys across the state, both on the defense side and the prosecuting side. But if we don't suspend this, whether it's 2 years or 3 years, what mischief might occur in our criminal justice system, perhaps by a handful of defense attorneys who might take advantage of the minutia of the statutory protections we've got in place, if that makes sense.
I think I understand that. I mean, the obvious strategy right now is if something doesn't happen, is every single defendant should request a jury trial and ask for their 150 or 180 days, knowing full well that there's no way the courts or the district attorneys and county attorneys' offices can accommodate it. And we're going to have to pick and choose and just be stuck with which ones we dismiss and which ones we try to squeeze in that time frame. I mean, that could happen. In the normal, when things were normal before COVID, that didn't happen because a lot of times the brink of jury trial, that's a lot of times what gets cases settled. So when I say we have 35 cases waiting to be tried, it wouldn't be that high in normal times when we'd be trying them on a regular basis. But two, as those were set, we might have that many set. We don't think those are all going to go. As we get closer, that oftentimes leads to pleas. Their bluffs is called when the state shows up ready to try a case. And I would agree with Mark, it's not very often that the state is the one asking for the continuance and trying to push these out. Our cases get worse with the passage of time. Like Mark, I have a couple cases where I have lost witnesses. They are relocated. I had one that died. We've had some that have been deployed in the past. Passage of time hurts our cases. We like to get them tried as soon as possible, and we like to keep the cases moving. We're not trying to delay this. It's not our intent to deny defendants their right to a trial and keep them locked up without having evidence presented. And be careful in the Overbrook Tavern. I've had several cases come out of there from my days in Osage County.
Well, especially with the vice chairman here. No, I'm kidding, Mr. Ralph. Thank you, Mr. Jones and Mr. Chairman.
Representative Wheeler.
Just very quickly, I appreciate your sitting down and working with the sheriff on who you can release. When you release them, you're still facing the non-custodial speedy trial time, aren't you?
It only buys us 30 days under the current statutory scheme, from 150 to 180.
And just to make sure, statutory speedy trial is triggered at the time of arraignment.
Correct.
You're not delaying arraignments, are you?
No, we are trying to do everything we can. Prelims are going. We are doing sentencings. We're doing pleas. A lot of it, most of the judges are doing them by Zoom. My district court judge in Franklin County, we're still doing in person with social distancing and masking and sanitation in between cases. But we are trying our best to move as many cases as possible. However, there are certain defendants who I think see that, especially if they're out of custody, this is a delay tactic for them because they can just request their jury trial and it keeps getting kicked down the road and they get to keep being out. So that's another reason why they're stacking up on us, in my opinion.
Brandon, thank you for being here. No more questions.
Any further questions for Brandon? Not seeing
Yes,
any.
Mr. Chairman, you
Oh.
can't see my hand. I'm sorry.
Representative Carmichael.
Thank you, Mr. Chairman. I forgot about your technological difficulties. I'll try to raise my hand and turn my camera back on. Counsel, you agree, though, that criminal defendants, no matter how heinous the crime they might be charged with, they are presumed innocent unless and until proven guilty in our country, aren't they?
Absolutely.
And so while there's no advantage to the defendant, or excuse me, to the state in delaying these trials because you lose witnesses, recollections become poor, etc., for the innocent man who's sitting in jail awaiting a trial, there's a real powerful incentive for him or her to get their case tried so they clear their good name and get back to their lives. You do understand that, don't you?
Yes.
Okay. Now, my friend Representative Samsel, I think he probably misspoke, or maybe I just misunderstood what he was saying, but you do recognize that criminal defense attorneys also have an obligation under their code of ethics, just as you do, to, well, even more so they do, to zealously represent their clients and to advance the defenses that might be available to them. And so it's really not right to say that it's being crafty or devious by a criminal defense lawyer to advance a client's rights under the speedy trial statute. You're not contending that, are you?
No.
And in fact, you recognize that if defense counsel fails to advance statutory defenses, in some cases that may amount to ineffective assistance of counsel and lead to cases where there's been a conviction being reversed and the victims and their families and everyone else having to go through a trial again. You understand that, don't you?
Absolutely. It's extremely important to have good defense attorneys, or we end up retrying cases for those very reasons. And I've had to do it. I've got a murder case right now that I'm having to retry because of that very reason.
I appreciate that. And we all know, and I certainly know you well enough to know that you agree the same thing. The prosecutor's job is not to obtain convictions, it's to do justice. True?
Absolutely.
Okay. Thank you.
Thank you.
Any further questions? If not, just one more for you, Brandon. Normally, I don't get questions from Senate or House leadership, but I'm getting a little pressure from, my superiors wanting to know if you're satisfied with your state rep.
It's a work in progress. We're still trying.
Okay. I mean, he can do better sometimes. Okay. Perfect. Good to see you.
Thank you very much. I appreciate everyone's time.
Next online, we have Sheriff Easter.
Good afternoon, legislators. I appreciate you taking the time to hear testimony on this bill. I presented written testimony. I think, I know I'll keep this very brief. The fact of the matter is that we are in unprecedented times. In the beginning of the pandemic, worked with the DA's office, worked with some defense attorneys, judges, to start releasing the more non-violent offenders out of jail, because we knew that at the end of the day, we were going to be way overcrowded with the amount of violent crime that is taking place in this community. And so right now, the Sedgwick County Jail itself is, we're a little over 75% of the inmates that we are holding are looking at felony charges, most of which are violent felony charges. And their bonds are such that they're not bonding out. Currently, as of yesterday, it was 113. As of today, it's 114 individuals that have allegedly committed murder or have been charged with the crime of murder. I mainly speak here on the fact that it is very difficult across the state of Kansas for us as sheriffs to sit here and look at speedy trial and say, after 150 days, with all the other remedies that are in place and those type of things, that we would have to look at a victim's family and say, oh yeah, this murderer got off, without even going to trial and without even seeking justice. Justice is about that individual having all the rights in the world, facing their accuser, having a speedy trial, those type of things, and being judged by a jury of their peers. That's what we as the sheriffs in the state of Kansas also uphold. But on this particular situation, it is very difficult in this current environment to ensure that victims are going to see justice as well because of the 150-day rule. Listening to all the testimony, it appears there's going to be some type of compromise, which we appreciate. you even entertaining that. And so I just want you to remember that none of us here at the Kansas Sheriff's Association is trying to say, hey, we need to do away with this and this, that, and the other when it comes to individuals' rights whatsoever. We truly believe in those individual rights. We believe in what defense attorneys' jobs are. And we are simply here holding folks to make sure that they have their day in the courtroom and justice is served, whether that be conviction or not a conviction. And so, but it's very difficult right now to even get to that point because of the limitations that we're seeing with the 150 speedy trial statute. And we ask that you really take a look at this and see what it is that can be done. Some type of an agreement, some type of extension, those type of things, so that victims and their families can also realize justice. So with that, I'll take any questions.
Thank you, Sheriff. Any questions? Representative Carmichael.
Thank you, Mr. Chairman. That works a lot easier, just raising my hand. Sheriff Easter, I always want to compliment you. I mean, you do a great job. You run the largest, I think, hotel and psychiatric institute in Sedgwick County. I don't know how you manage to enforce the law and keep us straight with all the responsibilities you have just to house those awaiting trial. And I don't think you're going to find anybody on this committee that I know of who doesn't think that we need to extend speedy trial, given statutory speedy trial, given the circumstances that we're in with the virus. But the converse side of this coin is the longer it takes to get somebody to trial, the longer they're part of your jail population. And you can only push that so far until you get to the point where you just don't have any beds left at the jailhouse. And so I think there is an advantage to sheriffs to see cases get tried as quickly as reasonably possible, because if the defendant is innocent, then the defendant needs to be on their way. And if the defendant is guilty, then they need to be on their way to the State Department of Corrections and not taking up space in your hotel. Do I understand that correctly?
Absolutely. And like I said, Representative Carmichael, it is a little bit different for sheriffs to even be weighing in on this type of legislation, because the fact of the matter is we're used to the rotation in our system where they've gone through the system, either got found innocent, pled guilty, got found guilty, and off back out on the streets they are with probation or parole, or off to prison. And that's what keeps the bed space rotating. Right now, we're not seeing any. And it is very trying. There's jails that are overcrowded. They have never been overcrowded before, simply because of this. But we cannot throw the baby out with the bathwater and say, oh, well, then we just need to start letting these folks out. We're talking about very violent criminals here, especially in our jail, that have allegedly committed some very heinous offenses. And we've got to see that day in justice. Now, once this is lifted, it's a whole different conversation when you're talking about doing away with completely with speedy trial, because I'm not sure the Sheriff's Association would completely support that for the reasons that you just brought up.
Okay. And Sheriff, I really appreciate the predicament that you're in. I just realized that if we extend deadlines 2, 3 years, etc., that's not going to stop people from coming in the jailhouse door, and you've only got so many beds. And if somebody doesn't go out the back door, you're going to reach a point where there's no room at the front door anymore, and then I have no idea what we're going to do.
Yeah, and I agree with you on that. I mean, we currently have people like that right now due to long waits at Larned for competency restoration. And I have a murder suspect that's sitting in here for going on 5 years now because of that. And so we do deal with certain individuals that spend a very long time with us, and a lot of it has to do with mental health issues. But this amount of folks, that this is not normal for any jail in the state of Kansas. But we have to, we have to look at this, what is best in protecting the rights of the suspected or the suspects, and what's best for victims' rights and making sure justice is served in one form or another. And that's why we're here today.
And then a final consideration is, I believe it'd be fair to say, and DA Bennett is there, but I think the DA is to some extent delaying filing some criminal charges right now because there's not enough room in the inn. And if we were to file all those too, then you'd be in one heck of a fix, wouldn't you?
Yeah, and that's problematic. There is charges that are not being filed for nonviolent crimes. And without getting into too much detail, with the drug issues that we have in this state, particularly in this county, they're out there committing more crimes when they could have been staying with me and maybe less victims. That is a portion of what is going on, but I don't want to speak for the DA, but he has to look at what is the best that he can do right now on charging those violent crimes, judges setting bonds, and people are able to bond out or not bond out for violent crimes.
Well, I wouldn't want either your job or Mark Bennett's job right now. I appreciate what you're doing, Jeff.
Thank you, sir.
Any other questions, committee? Not seeing any. Thank you, Sheriff.
Thank you.
Next on my list, but I'm not sure I see him on the screen, is Greg Smith out there in WebEx land? Okay, we'll take Greg's testimony as written testimony. We also have written proponent testimony from Steve Howe and Natalie Chalmers. Is there anyone else that's a proponent? Okay, I don't have any neutral listed. Is there anyone as a neutral conferee?
I can't hear you.
Oh, who's waving at me?
Mr. Chairman, Representative Curtis has a question.
Oh, okay, Representative Curtis.
Thank you. And I'm sorry, for some reason my video is not working. I tried Representative Ralph's, putting the light up by the video camera, but it didn't seem to turn it on, so I apologize. I was just wondering, I know we're hearing statistics, and I've reached out to Wyandotte County to see what our backlog is and kind of what the stats are there. And I know we're hearing stats from different counties, and I tried to look through the testimony. Do we have a handle on like what our data says statewide? Like what is the backlog? How, do we have any sense of like our statewide look at the issue?
I know Mark has some information from some counties. I don't know. Do you guys have anything else you want to add to that?
I will say I talked to Marcus Dupree yesterday, and he was trying to assemble numbers, so I don't have Wyandotte counties. As I didn't want to read it all into the I guess not a record, but read it all for everybody. But just ignoring Sedgwick County, because we've got 1,896 cases on file right now. But if you just look at the other numbers we've gotten back, it's over it's over 1,000 just with Shawnee and Johnson County alone. And then there's another 100, and ignoring Sedgwick County, there'd still be another 103 counties. I hate to try to generalize, but if you just kind of compare here, and you look at Riley County, Finney County, Franklin County, you can kind of sense, okay, Finney County, Ford County, we've got to be getting close, and just sort of extrapolate. 100 counties, 50 to 100 cases seems to be the general rule. Unless you're getting in one of the district attorney offices. So 5,000, something like that. And then, several more thousand when you add in the district attorney's offices.
Thank you. That's helpful. I was just trying to get a sense of what the numbers look like statewide. So I appreciate that.
Okay, we'll now move on to opponent testimony. And first up is Jessica Glendenning. And Jessica is online. We're not hearing you, Jessica. Yeah, if you're new to WebEx, except my computer's not on, but I believe at the bottom of your screen, kind of towards the left edge. Yeah, it looks like actually your mute button appears to go off. what I'm wondering is
Can you hear this now?
there we go. Yep.
Okay. Just had to play with the settings a little. I apologize. Thank you, Chairman Patton and members of the committee. I'm here on behalf of the Kansas Association of Criminal Defense Attorneys. I'm not here to say that DAs are going to intentionally delay cases. I'm not here to say that we should try all our cases within 150 days of whenever we start back up. I'm not even here to try and exploit minutia such as the Constitution to get defendants' cases dismissed. I'm just here to say that 2078 is not the answer to this problem. Statutory speedy trial has not historically been a problem for our courts or our prosecutors. And as Mr. Bennett noted, in Sedgwick County, which was long the largest jurisdiction in the state, there was only one case he could recall in 27 years. This is not normally an issue. The cause of the current concern is based on COVID-19 interrupting the ability to try cases safely. Mr. Bennett also cited to a recent Court of Appeals case, State v. Queen, and I'll address that as well. The COVID-19 backlog of cases can be handled in a way that does not violate constitutional speedy trial and does not destroy our statutory provision. We have proposed a couple of alternatives in our written testimony. And what we believe needs to be done at this time is to find a way to protect speedy trial and allow for adjustments based on the ongoing pandemic. This is a scenario that none of us have experienced in our lifetime. We don't know how this will play out. A blanket extension to May of 2024 or any date for that matter is going to be a problem. And the reason it's a problem is that there's no unique factual finding to determine whether it's reasonable under the Constitution. If we put a blanket extension for 3.5 years into the statute, prosecutors are going to rely on that and courts are going to rely on that. Without making any specialized findings, that may very well violate constitutional speedy trial. That may lead to dismissals in cases throughout the state, as well as violations of defendants' speedy trial rights. The current statutory speedy trial provisions don't just work because they're a bright line rule. They work because they're a bright line rule and they are always within the constitutional speedy trial timeframe. Setting a bright line rule that might not be constitutional could create reversals and most certainly will invite many appeals on that issue. Abolishing the speedy trial statutory timeframe for all cases filed after this bill would be a change to the laws that have been on the books since we became a state. This is not necessary. Mr. Bennett cited to State v. Queen, but I'm here to say that case should not inspire a change in the law. In that case, the court apparently miscalculated the speedy trial time frame or misspoke when it stated that April 30th was the speedy trial deadline. In fact, it was actually March 30th. The court asked the prosecutor if that was correct, and she affirmed that date. The trial was set, and it was 3 days outside the statutory speedy trial date. The Court of Appeals reversed it and said the remedy was dismissal, but that case is still pending before the Supreme Court and not final. Our current speedy trial statute is kind of like a speed limit. It gives us a bright line rule to follow. Drivers know if they are under the speed limit, they're not going to get a speeding ticket. That limit is set at a speed that the Department of Transportation or some other authority has determined to be safe. Just like our speedy trial timeframe is set by the legislature to be safely within constitutional speedy trial timeframe. Now, it might seem unfair for one driver who's going 76 and a 75 to get a ticket, where another driver going 75 does not. After all, that's only a mile-an-hour difference. And what if that first driver's speedometer was off? But if that rule was to drive at a speed that was reasonable instead of a set speed limit, how much time would we devote to examining every speeding ticket, researching the weather conditions, the traffic patterns, the type of vehicle, the safety features on the day that that ticket was written? We recognize that that would be difficult to enforce and it would create unnecessary confusion and uncertainty. For any rule, it's possible to pose a scenario where that rule doesn't seem fair. And State v. Queen is a perfect example of that. It was only 3 days outside of speedy trial. Is it really fair if we dismiss that case? It was arguably a small error. But what you're being urged to do here in response is to increase uncertainty in a process that is well established and easy to follow. And you're being asked to do so because of either a mathematical miscalculation or negligence. I have practiced criminal defense in a number of different judicial districts, and in every one, I have seen prosecutors with a method of calculating speedy trial. Some places they have little wheels where you put the marker on today's date and then you spin it out 90, 150, 180 days to get the exact date. There's a website called timeanddate.com, which I frequently use to calculate days or to add and subtract days from any date on a calendar. It's not a difficult proposition, and it's something that prosecutors have been doing for years without issue. A mistake in one case is not a reason for a sweeping change to the law that's going to increase further litigation and uncertainty moving forward. If this committee feels that the statute needs to be amended due to this unprecedented pandemic, the statute could easily be amended to provide in subsection J that the suspension of speedy trial is subject to some other oversight rather than tying it to the governor's state of emergency declaration. It could also be amended by adding in a new subsection which allows courts to individually make findings on cases set for trial, allowing them to extend speedy trial for an additional time frame, maybe 90 days, because of the unsafe conditions or a backlog in cases. And that section could even specifically give the courts an opportunity to invoke that more than once. This would allow the courts to adjust during this uncertain time and ensure that trials are proceeding safely and still protecting constitutional speedy trial rights. An extension with a finding by a court that it was extended because the trial couldn't be conducted safely or because there are not enough judges to conduct a trial, that's going to pass a constitutional examination. There are far more tailored options that we could do in this scenario to address this backlog of cases. We're asking that you don't pass House Bill 2078 as it's been proposed. We would ask that you consider an option that is more tailored to this specific problem and not throw away a law which has served our state well for the past 160 years. I would stand for any questions.
You first up is Representative Sampson.
Thank you, Mr. Chairman, from the Tavern again. Thank you, Mrs. Glendinning. I'm getting background noise. I apologize if that's coming through. One of the challenges of this job is finding time to carefully review all this. Now that I've looked at your options towards the end, I think you have some very reasonable proposals there. And my question would be and I'm not throwing shade or rocks at anybody, but you guys have obviously lived this for much longer than at least I have, and probably many of my colleagues. Have you had an opportunity to, and I'm not, again, I get everybody's busy and everyone's moving quickly here. Have you had an opportunity to speak with the proponent as to where there may be a good solution to this or common ground versus rather than having my esteemed colleagues here come up with a resolution, if that makes any sense?
It does. I have not had the opportunity to talk with them. I've had cases with Mr. Jones before, and I've spoken with Mr. Bennett before. I'd be happy to talk with them. We'd be happy to be involved in coming up with any additional language or helping draft changes during committee meetings.
Thank you. I thought that might be your answer. I suspect the proponents might also be receptive to that. I would wholeheartedly, I suspect, support if there is some solution there that's agreed upon by the folks. And then on a personal note, I do want to apologize to the defense bar, as my colleague from Sedgwick County pointed out. If the mischief I was referring to was somehow taken as a personal affront, it was not intended that way. I assure you, as a legislator, we probably cause a lot more mischief than anybody else. So I appreciate your very difficult jobs and service. Thank you, Mr. Chairman. Thank you, Mrs. Lindenberg.
I did not take it as an insult.
Representative Carmichael.
Thank you, Mr. Chairman, and Representative Samsel, I didn't mean to cast any aspersions at all. It just kind of came across that criminal defense lawyers are crafty. Well, others would say they're zealous and diligent in the representation of their clients. That's the only thing I wanted to point out there. However, Ms. Glendinning, I agree with you that the prosecutor who fails in each case to have evidence of record that articulates the reason for delays of trial does so at his or her peril, because without a supporting factual record, a federal court someday may conclude that there was a denial of speedy trial and the guilty go free. But that's a decision for the prosecutor, not for me. I also understand your reluctance to go along with a hard and fast deadline extension, if you will, because it's not tied to any particular facts in any particular case. On the other hand, if we've got 1,400 defendants or whatever it is awaiting trial in Sedgwick County, and each and every one of those cases has to now go to a hearing or a determination by the judge based on the facts presented that there should be an extension, I fear that we'll also clog the courthouse with doing nothing but hearing repetitive motions for extension of speedy trial based upon the same facts. We can't get jurors. We've only got 2 courtrooms. The witnesses can't be here. So I don't know an answer in my judgment that's better than a blanket extension, realizing that both a state court and a federal court could say, we don't care what the Kansas legislature thought was speedy trial. We're going to look at this defendant and conclude that this person was denied their rights and they're turned loose. So those are both observations. Now, my real question. Mr. Bennett pointed out that even in the largest prosecutor's office in Kansas, they don't have that many death qualified attorneys to try capital cases, let alone major felonies. I suspect it's even worse at the Board of Indigent Defense Services. What in the world are we going to do if we get around to March the 31st and you've got to try all these cases within 150 or 180 days? Are there enough prosecutors, defense lawyers, to give these people their constitutional right to an effective defense?
I want to address that, and I'm trying not to do so in a kind of joking light, but normally in the legislature, when I hear people talk about death penalty cases, all I hear about is how defense attorneys drag them out endlessly and do not want to actually go to trial. I'm not sure that there's going to be a huge issue with getting death penalty cases to trial within statutory speedy trial, because many of those defendants, probably most of those defendants, waive their right to speedy trial because those cases are so complex and defense attorneys have to speak with experts. They have to do a lot of investigation, not just as to the guilt or innocence, but also mitigation. Those cases are exceedingly complex and they are not normally tried within speedy trial timeframes. As to your question about the findings on individual cases, I have not practiced in Sedgwick County, but in Douglas, Shawnee, and Johnson County, they have large dockets where they will address large numbers of cases at a time. I would imagine that a court could put together a trial docket where they would call all the cases set for trial or split them up into a couple of different dockets, call them all and make a blanket finding as to the state of the current court backlog. which would then be part of the record in each of those individual cases. I don't think it would be extremely burdensome to accomplish that.
You have more experience requesting continuances in criminal cases than I do in civil cases, so I'll defer to your expertise. Thank you, Mr. Chairman.
Any other questions for Jessica? Don't see any. Thank you, Jessica. Next,
Thank you.
Austin Spiller.
All right. Thank you, Chairman Patton and members of this committee. Really do appreciate this opportunity to present testimony today. I am the policy associate with the ACLU of Kansas. And just in case you don't know, we are a nonpartisan, nonprofit organization that works to preserve and strengthen the civil liberties and rights of all Kansans. And the bottom line here is we oppose HB 278. So I'm going to lay out some of the reasons why we oppose it. First, this bill is an affront to the constitutional rights of all Kansans. The right to a speedy trial is in our state constitution and it's in our federal constitution. And suspending these constitutional rights until 2024, in fact, will only exacerbate the existing systemic inequalities and racism that is currently within our criminal legal system. And we do acknowledge that there are very real challenges faced by our courts and the criminal justice system during this pandemic, but stripping people of their constitutional rights is never the answer. In fact, our constitutional rights are even more important during seasons such as these. The next point that I would like to make is that this bill will likely result in significant costs to residents and the state. The cost associated with electronic monitoring and pretrial supervision will explode. And as a practical matter, we will have innocent people languish in jail because they are simply too poor to pay bail. People will lose their jobs and their family budgets will be decimated by this approach. People out on bail under a pretrial supervision system will encounter disruptive and unnecessary bureaucratic hurdles to maintain compliance. This runs counter to other bills the state legislature is advancing this season to address the criminal justice reform and to the efforts of the state commissions in the same vein. Finally, this bill does not comport with this legislature's expressed desire to prioritize the continuation of essential government services during this pandemic. And the courts, they have an obligation to minimize the health risk to the public, which includes risk to persons charged with criminal offenses and imprisoned Kansans. This obligation includes maintaining provisions for release from custody. And with that said, officials must consider alternative means for people to access the courts, counsel, and government offices. Another issue that I would like to address with this committee as a broader matter, and that is it is well within the purview of this committee to introduce and hear bills to decriminalize certain nonviolent offenses and to eliminate the potential of jail or prison time for others altogether. Doing so would tremendously help alleviate the backlog caused by the pandemic. It would help to avoid infringing on people's constitutional rights and save the state money and resources. And not to mention, this would also help create a more just and equitable criminal justice system in the alignment, with the goals of the criminal justice reform efforts in this state. So thank you again for the opportunity to present virtual testimony to this committee. I'm happy to answer questions or be of additional help, and I'm happy to stand for questions at the appropriate time. Thank you.
Thank you. Representative Samsel.
Thank you, Mr. Chairman. Very brief question to the reviser, Natalie, please. And this may be helpful in particular to our non-lawyer colleagues and friends, but I just want to make sure this bill in front of us today does not affect any constitutional rights, correct? My understanding is that we have the Constitution in place. This bill will not affect it. And then the legislature in the past, out of sound wisdom, has put in additional detailed statutory protections, which we may or may not change in this bill, but we're not doing anything that alters the Constitution, if you will. Can you help me understand that, or am I wrong?
Mr. Chairman, Representative Samsel, we are not amending the Constitution in this bill. In fact, we can't amend the Constitution in a bill. That would be done by a concurrent resolution. And so all this bill would impact is this statutory speedy trial right. No changes to any constitutional speedy trial.
Thank you, Natalie. My very narrow question then is, I think the testimony was that it would strip them of their constitutional rights. Perhaps a more accurate way of saying that might be that it might strip them of statutory rights, which is, I hear there's a strong objection to. But I'm curious if the opponent do you disagree that this wouldn't affect the constitutional rights?
Thank you for your question, Representative Samsel. And I believe actually the previous opponent, Ms. Dundling, also kind of alluded to it. Even Representative Carmichael. I mean, when we are talking about extending this out, till 2024, another 3 years. So you have potentially, people waiting 4 years. That is certainly an issue that erodes that constitutional right. And also, the point was made earlier that, this, there is not this individualized test that the courts will be making to determine, the resulting prejudice, the cause of delay. So that is a very strong potential for, you're right. It's not changing the Constitution, but the reality of the effect of the statute, the way it is written, will essentially act like that. So that is the point that we were trying to make when we were saying that is stripping away people's constitutional rights, that this bill is so extreme and does not, like the previous opponent said, like acknowledge the realities that, we recognize that, we are in a pandemic. This is unprecedented times, and we are not saying that, there absolutely cannot ever be delays. Delays will happen, but this broad extension till 2024 is essentially a stripping of the constitutional rights.
Thank you, Mr. Reinecker. I understand your position. I guess my very heartfelt concern is we learned, I think, all of us from our nation's capitals events that our words do matter very much, and I'm not casting any stones. But I know anytime I go back home in my district, we are very huge proponents in all political affiliations of our Constitution. So when I say I'm stripping constitutional rights, I just wanted to make sure my understanding of what was taking place was accurate. I appreciate your testimony. I understand it. And thank you, Natalie, for your explanation. And thank you, Mr. Chairman.
Representative Carmichael.
I'm sorry, I didn't mean to have my hand up. It was for the last time. I apologize.
No worries. Representative Neely.
This doesn't have to do with the actual Constitution part of it, but the speaker there just said that he opposed, or the one that was opposing it there, said the price of home monitoring would go astronomically high. And my question is the price of that compared to housing them in the jail, is there a comparison to that as to why that would be a larger issue than having them released on home monitoring?
If I may, Representative, there are some statistics. I'm going to just speak in approximations. It is approximately $72. Well, that's in prison. $72 a day in prison, but it's about $7 a day for someone to be under supervision. So yes, there are cost savings to have someone on supervision versus sitting in jail or prison. However, our community supervision agencies are already, certainly burdened with their caseloads as well. And what this does is this will, we could potentially have people on pretrial supervision for much longer periods of time than was previously anticipated or budgeted for. And so that is one reason why, that these community supervision costs to the state can go up.
Any further questions? None. Thank you, Austin. Committee, Nick Reinecker has submitted testimony and it will be written. Anyone else here as an opponent? Seeing none, closing the hearing on House Bill 2078. Committee, if you want to have a heads up on the bills, we may be working Thursday. Here is a list. I'll go over them again tomorrow. Everyone have a chance to get a piece of paper and a pencil. 2049 and 2050, those are the bills from the legislative post audit. I believe we have an amendment that I know of coming on the first one. House Bill 2071 is the minor stalking bill that we heard last week. And then the three bills we heard yesterday, House Bill 2079, 2080, and 2082. That's the Safe at Home Act, the Charitable Organizations Bill, and then the one we had from the Crime Victims Compensation Board. So those will be up for Thursday. But again, I'll repeat that tomorrow and give you a heads up. But in case you want amendments, you need to be getting to work on them. Does anyone have anything else? Not, we're adjourned. Thank you, committee. We'll see you tomorrow.